So I thought I'd actually start by framing a little bit the discussion again of why we're doing this. We've heard multiple times about the growing complexity, the explosion in complexity of European digital law. I thought I'd put a few numbers on it. The Draghi report actually takes their number indirectly from work that Kai Zenner and I do. You might be aware, some of you, that he and I together publish a data set, a directory of all EU digital laws. And I can say that in that data set, you'll find that in 2012, there were 20 laws enacted. As of last summer, it was 88. So an increase factor 4. And the statistics also say that the average length of EU laws generally has approximately doubled over the past 20 years. So what we're talking about here is a level of complexity that really even the best experts struggle to keep up with, and in particular, trying to understand all of the opportunities for ambiguities or perhaps even conflicts across those laws becomes a real challenge. Now, I had the honor of speaking at the previous event a year ago, a previous EDPS Clearinghouse 2 event, and at that point, I think the room was still pretty divided as to whether it was necessary to do more. I think what we're hearing today, my sense is that there's a growing conviction that it really is necessary to somehow do more to coordinate across the bodies of law in different ways and to find structures for doing that. As we've also heard, the issue of coordination across the silos is somewhat interrelated, not totally, but somewhat, to cross-border issues, coordination, in other words, among the member states and between the member states and the Commission. So these are actually somewhat linked problems. Now, what we have today is an absolutely outstanding group of experienced experts, and experts in actually many different dimensions of this very problem. Experts in European telecommunications law, in data protection, the EDPB, and also in some of the member state initiatives to try to resolve these issues. Also experience with the DMA high-level group, which, as we've already heard, is really one of the most interesting attempts at European level to work across the silos. So what I'll be doing really is polling my very talented panelists here who have experience hands-on with this, which I don't, to really see what their experience has been with this and where they think things could go, where they think things should go, especially what's working and what's not working. Actually, also by way of introduction, I'd add a few words of special thanks. Several of my panelists really had to do heroic efforts to get here in the face of the train strike. So much appreciated that you're here at all. Everybody is here. That's a good thing. With thanks to that, maybe we can start with electronic communications law and the coordination there, both within the member states, but especially across them. We have here two experienced telecoms regulators. Perhaps we could start with Robert Mourik, who through his role with BEREC, the Board of European Regulators of Electronic Communications, has an especially broad experience dealing with exactly these problems for a somewhat different body of law. But as we've heard, telecoms is one of the areas that intersects with data protection. We know that the UK effort includes Ofcom, so there's a lot of crossover in all of these areas. And with that, over to you, Robert.
Thank you very much, and it's a delight to be here. In the telecommunications sector, there has been a, let's say, European collaboration between the national regulators for the last 25 years. And that happened the last 15 years within the framework of BEREC, which is the organization, the European body for telecom regulators. And there we have a very organic way of harmonizing and of cooperating. There is basically a daily communication going on between regulators that say, I have this problem, how do you solve that in your jurisdiction? I have this issue, or I've solved it this way. And so there is a kind of a harmonization from the bottom up, because all these regulators have one thing in common, and that is they have to regulate the telecom sector. This is now changing, not necessarily in the telecommunication sense, but some of our members have been given some additional remit in some area. I myself, I'm doing NIS2 for a number of sectors, not for all, but for some. I'm doing this, the CER, I'm doing a bit of the AI Act, but there is not a single regulator in Europe that has exactly the same mandate that we have. We've done a table of what regulators do, what kind of jobs, and you will see a really wide diversity between them, and that is immediately a barrier, because you can't pick up the phone to the same person in the Danish regulator or in the Greek regulator and say, how have you solved this? Because with regard to digital regulation, that unifying thing has fallen apart. And that is logical, because data and digital is not a sector. It is something that is by definition cross-sectoral, and each government decides itself which of the existing regulators can do what. But that is immediately an answer to your question, but also one of the barriers that I currently see. So the Commission has literally said in meetings of BEREC, they said, we would love BEREC to be the coordinator of this, that, or the other in the digital space, but the remit of many of your members is not suited to it. So there you go.
Yes, and actually, even within classic telecoms, not all of your members have exactly the same remit. Some, for example, don't have spectrum management competence.
Correct.
So it's a complicated world. So, Martijn, you also work with that. Does that line up with your perceptions?
Yeah, absolutely. I think we've created a sort of archipelago of different laws and different regulators, where you come up with, hundreds of different little islands. Some islands are co-owned by regulators, others aren't, and that makes it extremely difficult. And that's why I fully agree with your statement, is that I'm convinced that cooperation is absolutely necessary. We need to connect these islands in order to create one country. That's the imagery that I have in my mind. And one thing that I think many of us in different European formats are struggling with is that there is a difference between coordination and cooperation. Coordination is a sort of, well, you make sure that you're not entering each other's territory. If you think about that you stay out of each other's island. And that's already a task, but that is doable in a way. And you see that most international networks have a strong coordination system to ensure that everyone stays on its own turf. But with doing that, basically you're missing out on the great opportunities you can get with cooperation. And that is something that we will talk about in this panel further, is how do you achieve real cooperation? That's meaning that working together and ensuring that these islands actually form one country instead of an alliance not to invade.
Yes, now I like that. What we heard in some of the previous panels is that cultural alignment is at least as important as legal alignment. I think I see a nod, so...
Absolutely. I think I'm a bit skeptical about... Institutional arrangements are necessary, and memorandum of understanding are necessary, but really, they do not create cooperation. They are a sort of necessary building block, but ultimately, in order to achieve cooperation, you need to work together, and we all know how difficult that can be. And that comes with a joint culture, a joint mission, a joint understanding. And that is hard work. That's not unique for government institutions. It's the same in big companies. It's not unique for the EU. You have the same in the federal system in the US. So we shouldn't beat ourselves and tell us all the time that we're not capable of doing it. It is just complicated, and we should learn from different organizations, both private and public, and incorporate best practices.
Thank you for that. Well, moving over to Anu Talus now and moving to a different thematic area. So you're chair of the European Data Protection Board, the EDPB. So how is EDPB dealing with, I mean, many people, I think, have a good sense of what you do across the member states, but I think you also have a lot of cross-sectoral initiatives, and I'd be interested in hearing about both and what you think is working and where you think more is needed.
Yes, indeed we do. We actually, I would say that we have three different angles when we are looking at the cross-regulatory cooperation. So if we start at the EU level, of course here we do have the cooperation with the different regulatory bodies. We have actually taken some initiatives already in this respect. If I then just go first through the other aspects or other angles as well, and then come back to the actual cooperation. So this is what we do at the EU level. Then you already referred to the cross-border cooperation. So we are cooperating between the data protection authorities at the national level, and this is something we have now done for quite a long time. It was an entirely new system established by the GDPR, but now it's functioning quite well, and this is something where we have learned a lot. But then there is also a third angle, I would say, what all the national data protection authorities do have. They also need to do the cross-regulatory cooperation at the national level. So the national data protection authorities who are members of the European Data Protection Board, they need to do the cross-regulatory cooperation at the national level. Then they do the cross-border cooperation with the other data protection authorities, also at the national level. And then we work at the EU level, at the European Data Protection Board, and the EDPB do the cross-regulatory cooperation with the other EU bodies. So there are, I would say, three different elements or angles put together. So we put together both the national and the EU level cooperation. I think it's always important to remember that we need to be able to combine both of these when we are talking about cross-regulatory cooperation. And the cross-regulatory cooperation is actually one of our strategic priorities. It's something we really underlined in our Helsinki statement last summer, that this is something where we want to put focus on. We have done that by so far, and this is also perhaps I could give some examples what we've done by so far. For example, under the when it comes to DMA, which it overlaps with the GDPR at some level, we have worked together with the Commission to have a joint guidelines when it comes to application of the GDPR and the DMA. And now we are also working closely together with the Commission on the guidelines on AI Act and the GDPR. So to start at a very early phase, when you are having these fields which are overlapping, it's very important so that the issues do not escalate before you start the cooperation, but you should start at a very early stage.
That's helpful. Now, EDPB and Commission have very different competences. Has it been difficult to sort out who does what, or has that been fairly smooth?
Yes, of course we have. We are data protection authorities. Indeed, we do have different competencies. We approach, of course, from our own angle these topics, these issues. And I think what's also important to note that when we are talking about the EDPB, you already have all the national data protection authorities angle there. So this is also something I think it's quite important to note.
I think that's in line with comments that we heard earlier today too, that these different perspectives can actually have synergy. And I think that's what I'm hearing from you. Okay, now, part of what we heard here was the need to orchestrate cooperation within the member states, and both Martijn and Robert actually are very active in the activities within their respective member states. Don't worry, Jan, we'll come back to you in a minute. So with that said, and actually, by the way, with Martijn, probably useful for you to explain the many different hats that you wear, because your agency deals with a lot of different topics already. You're almost a multifunctional entity yourself. So how does it work in the Netherlands?
Yeah, maybe to start with, the ACM, the Authority for Consumers and Markets, is in the Netherlands mandated with we are the Competition Authority, the Consumer Protection Authority, the Telecoms Authority without spectrum management rights. We are the Energy Regulator, the Public Transportation Regulator. Did I forget anything? I think, and did I mention competition? Yes. So that's a mandate, and for a relatively small country, we're a sizable agency. We are close to 900 people, and we also do the DSA and the DMA and the Data Act and the Data Governance Act, and I think that's about it. But we're also, I would say, one of the siblings of the DRCF. And in fact, all credit goes to the DRCF. I read about the initiative when it was launched, and I immediately said, well, that's a good idea. So I called my colleagues at the Privacy Authority, at the Media Regulator, at the Financial Conduct Authority, and said, this is a good idea, let's copy that. And so we did. And so it's a good idea that was stolen, although we implemented it slightly different. A year later, we added the Cybersecurity Authority to the team, and the reason why originally we were a bit reluctant is that the Cybersecurity Authority is not an independent market regulator. It's part of the ministry, so at first was for us a bit, I don't know, scary to cooperate with a non-independent, with a political body. But I think after a while we thought, well, it's crazy. We need them on board because it doesn't make any sense. And we deliberately chose not to create a separate body like the DCRF, because we thought, well, maybe let's start it slow. We have a board in which all the member authorities are represented. I chair that board, and part of chairing the board is also the idea is that you provide a secretary that takes and one or two assistants that help in preparation with everything. I think the first year was devoted on getting to know each other and also getting the organizations on board, because this was really an initiative that was done at the president's level, and you know how that works in organizations. If the presidents think it's a good idea, it doesn't not necessarily mean that it will actually be executed at the working level. So it took a bit of persuasion to get all the, the hesitations and the risks and everyone on board. But I think after a year, everyone felt comfortable that we can do this in a right way. So the second year, we decided to go outside also with joint advocacy. So we approached for the first time together Parliament. We talked to the Council of State about the implementation of the DSA and the DMA. We talked about the other digital laws and ensured also that there would not be a public fight between the agency on who would get which power and in what form. So we cut up the cake ourselves rather than to leave it to the politicians, and they followed our advice. I think that was helpful and was also a way to build trust among the institutions, that we were not trying to get behind each other's backs and get a bigger piece of the cake than others. Then the third year, we thought that's really necessary to take a next step, and we started discussions on priority setting. Not priority setting for our entire work, but kind of priority setting for the corporation. What areas will we focus on? protection of minors, and resilience. Basically, those were the two themes where we would focus on in our corporation. So that was one thing, and we made sure that we had working groups where people exchange ideas, exchange know-how. But this was, relatively low-key and easy. The second thing we did, and I think that changed the structure of our corporation, that we set up an early warning system. That means that all investigations launched in the digital sector would be notified to all the other authorities, with the idea is that if we are thinking about this, approaching the same company, and at the same time it's good to do that in a coordinated way. Sometimes we go after the same behavior with different laws. It's also good to coordinate that. And that really helped and made also a smaller step towards real cooperation. And then the final thing is what we did. This was last year for the first year, that we started with kind of a regulatory dialogue with identified big digital companies, and we approached them that we would like to see them jointly. So with all the regulators, and that I think that. Of course, that made people a bit nervous also at the agencies, because, what are we going to do? And it also made the companies a bit nervous because, wow, suddenly I'm faced with all these regulators around the same table, and now I can no longer play one out against the other. So, and we did now 1 or 2 rounds of these discussions, and actually it worked really well. For 2 reasons. Because the most important reason, it made our cooperation real. The preparation of these meetings need to be done meticulously, obviously. And through this kind of preparation, the institutions got to know each other better, really understood better what the investigations actually were, how to deal with it, and how we can coordinate on these investigations. And on the other hand, it really gave, for some companies more than for others, but it gave the digital companies, kind of evidence that we are serious about it, that we have skin in the game, that we really want to make this work, and that we are setting up this regulatory dialogue on a consistent basis. It's not perfect yet, by far, and there's lots of room for improvement. But I see this as a very important step in our development. What we haven't done yet, and that is high on our agenda for this year, is really to set up joint investigation teams. And where we have an integrated team from different agencies that do an investigation jointly and come up with a joint product that then, of course, needs to go into the legal procedures and alleys of each individual agency. But that is, we're looking for a good candidate to have a joint investigation. But I think that will be the proof of the pudding, if we can get our cooperation into the next stage of development.
I suspect that the market players in the audience hope that they won't be your test case. As far as taking inspiration from the Brits, I don't think you have to be too full of guilt feelings about that. It's often said that all authors borrow, but great authors steal. So off we go. We'll come back to the cybersecurity point a little later, I think, because it comes up again in regard to DMA and the high-level group. Now, one question I did want to ask before we move on. I know it's often said, and we also heard this from Wojciech earlier today, that information exchange between the agencies can be a challenge. When you and I spoke about this before, you said that there are ways to deal with that. Could you elaborate a little on that?
Yeah, so this was one of what we did in the first year, is say, what can we do now, what needs to be developed, and now it's a patchwork of some of the agencies are allowed to share data with other agencies on a statutory basis. Others have entered into memorandum of understandings, and others can, have to be a bit more careful, and then we do this in a sort of more anonymized way. This is not ideal. And what we ask for our government in a kind of in the next iteration of the relevant laws is to give a blanket permission to all regulatory authorities to exchange the necessary information for their cooperation. But we are not there yet. So now we do this with some bandages and some memorandum, and it's not ideal, but it's better than nothing.
Many thanks for that. Okay, I'll come to you in just a second, Jan, because I want you to keep everybody honest. Okay, but first I'd like to hear from Robert Mourik on this. Now, you also have an institution within Ireland that does some of the same things. We heard a bit about that earlier from John Evans. I'd be interested in getting your take, and perhaps especially an understanding of how that interacts with data protection.
Yeah, you will hear me saying more or less the same thing as Martijn, and I'm going to echo what John said earlier this morning. Is that, but the way it was born is slightly different. We have an economics regulator network. There are 7 or 8 members of economic regulators, and the data protection regulator is not a part of that group. But that group saw this whole diarrhea of digital regulation coming at us, and we thought we need to understand better what it is that is facing us. So actually, it was John and myself. We commissioned that study that tried to map out what the digital regulation was, and from that. A subgroup of the economic regulators was born, which was then initially called the Digital Regulators Group. But that Digital Regulators Group was not complete without the Data Protection Authority. So we got them on board, and that kind of then you have the 4 most important digital regulators in Ireland. And it allowed us to, first of all, go to the government and appeal for extra resources, because you know what governments are like. They try first of all to just say, that's the task you have, and you have to do it with the resources you already have, and that wouldn't have worked. And it wouldn't have worked in particular because in some pieces of legislation the country of origin applies, and we have to be basically the European regulator in some areas, be it in NIS2, for example, or on the DSA. So it was the first task that we did together was try and convince government to give us the required resources to actually do that job. And from that, we're starting to develop more now into looking at what I thought was the original mandate, is to make sure that nothing falls in between the cracks of the different regulators. The digital is quite a wide topic, and we may have 4 nice boxes, but there may be a lot of problems that are neither mine reading nor that of another regulator, and then nobody does anything. So this group was also set up with the intention to look into those topics that we don't necessarily feel are completely within our mandate, but we need to work together. And in order to do that, you do need a secretariat of some shape or form. You do need a bit of guidance and a common plan, and we're now working on that. We're not as far yet as what Martijn has just described in terms of joint investigations or anything. We're in that sense a bit more tentative.
Okay, thanks for that. Now, you talked about areas that might fall between the cracks, but there were probably also areas where more than one of your 4 parties would claim some degree of competence?
Yes, but the advantage of the ERN was that there is absolutely no turf war amongst the Irish regulators, because we know each other so well. And so I never considered that to be a real big issue. The problem was more that we forgot to look into certain things, or that certain things really cried out for action, and we didn't have it on our radar.
Thanks. Okay, so Jan, you've been waiting patiently, and You're in a little different role here than the other speakers because you represent an NGO, you represent civil society, so you're in a little different role here. But I'd really welcome your view, both pro and con. What do you perceive as working about this process? What do you perceive as not working about this process? What do you think about what you just heard?
Sure, yeah, and I do feel a little like the odd one out because so EDRi represents 15 digital rights organizations across the continent, and we do have an outsider's view on the regulatory processes that are happening. Maybe let me start off by saying that obviously the diarrhea of tech laws didn't come out of nothing. It was a direct result of real digestion issues that we had in the tech sector. So those needed to be solved, right? And I also loved the numbers that you brought up in the beginning. So I think those 20 to 88 tech laws kind of increase of numbers, that fairly well represents the increase of level of complexity that we've seen in the technology that we use every day and the stuff that's thrown onto the market. So in a sense, I think that's actually quite a good sign that lawmakers are keeping up, or trying to keep up with the speed at which the industry is moving. There's a lot of things actually that do work well. We have, as compared to other regions in the world, I think like quite capable regulatory authorities, kind of broadly said. There is a number of things, of course, that we would love to see improvements on, and that I think are possible. And you mentioned resources. I think resources are really a key thing, because although you can have, as an authority, all the will of collaboration and cooperation, if you don't have the staff available, if you don't have the funding available, then that's going to be always very hard, especially if you want to involve 27 or more authorities. Information sharing has already been mentioned, and for us as civil society, that requires not only information sharing between authorities, which is absolutely important. I've heard on several occasions that it is sometimes a problem, that some authorities think that they have secrecy requirements or something that prevents them from sharing information with colleagues from other member states or other authorities, and that's a big problem. That shouldn't be the case. But for us as civil society, that extends to transparency towards the public. Because the power that regulatory authorities have has direct impact on people's lives. And so people need to know and have a right to know what's going on and what isn't going on and why. And to give you an example, of course, the prime examples at the moment are the DMA and the DSA, which are relatively well known for European regulations among the general public. And I say this very cautiously, but I think are relatively well known. But there is a sense that we feel in our membership and in the people that we work with and represent in civil society, that there is not much of an understanding for why things are moving so slowly. So even where there are very good reasons for things in the enforcement process to move slowly and carefully, those reasons aren't known to the public. The result is wild theories about how the Commission is trying to screw everybody over, or how just governments are doing a really bad job, or they don't want to enforce, or this is all kind of a toothless tiger and nobody cares about what's written on in European laws, and that's a big issue. It's a communications issue for authorities, but it's also a trust issue for democracy. If we enact laws and then afterwards people have the feeling that those laws aren't enforced properly, then we have a big problem in the long run. So I think transparency can help here, within the boundaries, of course, of what the requirements are and where companies can request certain business information to not be shared publicly. I think it's super important. And maybe two more items that I wanted to mention. One is, whatever these collaboration mechanisms are, and whatever the authorities feel is important as fora to establish, on top of transparency, political independence is absolutely crucial in all of those areas. Again, it's a question of perception. We cannot have the public perception that any other political areas, like trade policy, for example, have an impact on the enforcement work that authorities are doing. And I can't say how much that is a fact, but I can say that impression is absolutely dangerous for the trustworthiness of our public institutions. So I don't think that the European Commission is the best place to provide this political independence. They have done this relatively well, I would say, in the past decades in the field of competition policy. But in the field of the DSA and the DMA, for example, it hasn't worked so well. And I think that's partly related to a trust problem and a transparency problem. But again, I think if any of those avenues can be established as far away from the political centers of power as possible and made as politically independent as possible, that would definitely help the cause. And maybe as a last point, I do hear you, and I love the examples that you mentioned. I think it's good that some member states maybe go forward as pioneers and kind of show other member states how this can work, and then you can replicate this on the EU level or in other member states. I think that's always worth doing. But we will always, in these situations, have to deal with a small handful or maybe only one member state authority that is unwilling or unable to uphold that pact and participate in this. And that's why I think these mechanisms should always also involve a duty of collaboration for all authorities involved, so that we can avoid bottleneck situations in which one single authority or a small handful of authorities can slow down the entire continent and then make the whole process impossible in practice. I maybe stop here for the moment.
Well, thank you very much for those very thoughtful and insightful comments. Let me draw you out a little bit on one or two of the things where I think you had something in mind but stopped just short of saying them. So one actually had to do with the independence of regulation. This is actually something that Professor de Streel mentioned briefly in his remarks this morning, and he and I have talked about it. It's something that I know also troubles me. We're both sort of academics who deal with public policy in the general sense. So the member state regulatory authorities tend to be pretty carefully insulated from political influence for the most part anyway, whereas the Commission itself has both regulatory and political and industrial policy duties, and sometimes those intersect pretty closely. So really, I guess a first question would be, do you see this as an impediment that also flows into these areas? Relatedly, when we talk about public trust, to what extent do you see the deterioration, the market deterioration in the transatlantic relationship as putting extra stress on that because it raises new public concerns about why things might not be moving as one might perhaps hope that they could? So over to you, with a few hot potatoes.
Yeah, I do want to be careful because I don't think it's helpful to kind of accuse kind of individual people. I think there are a lot of good people in all of those authorities who are trying to do really good work to the best that they can in the structures that they work with. But I do think it was a mistake to put a lot of all that regulatory power in the European Commission and under direct supervision of the Commissioner, who has a very, very wide portfolio with a lot of responsibilities and who is obviously susceptible to pressures in other policy areas. And I think, and we said this publicly at the time as EDRi and as a network of civil society organizations, where we argued that, especially under the DMA and the DSA, this regulatory power should actually be placed in an independent authority. Sure, on the European level, why not? Because let's not forget that the regulated entities that we're talking about are the largest, most wealthy and most influential corporations that we have ever seen in the history of humankind. Right, so that's not an easy thing to regulate. That's not an easy thing to enforce against. That's a lot of power, economic power that translates into political power, as we can see today in the United States and have probably seen before in another scale. And I think that needs to be taken into consideration. I do not want to be in the Commissioner's shoes right now. It's not a pleasant space to be in, and I think we should have avoided her to be in that position in the first place. We could have, if we had put all that power into an independent agency, where the politicians could then have said, sorry, this is the law, this is nothing we can do, or this is not under our purview. And now we're in a situation in which we are, and that requires now the political level to invest a lot of political capital, which you would need in other policy areas, like foreign policy. And they have to invest this political capital now in order to make sure our tech laws are enforced properly. And that's a problem. It's a bit of a waste in a way. And it's risky. Because at some point, if a commissioner is faced with, oh, do I impose a fine on X or not, or do I risk the US leaving NATO? What are you going to do? It's an impossible choice. And we shouldn't have to make this choice.
Once again, thanks for a very thoughtful response. Okay, well, let's move on to another area then. One other thing that I wanted to cover with the panelists, where several of you have hands-on experience, is the DMA, the Digital Markets Act. Now, when we talk about cross-thematic coordination, probably the best example we have in existing EU law is the DMA high-level group, the HLG. And there we have multiple authorities that are systematically and institutionally exchanging views on some key issues. So once again, I'll be reaching out to each of you to say, based on your experiences, what do you perceive as working, what as not working? You know, actually, I would preface this by saying that when I talk to stakeholders, what I sometimes hear is that the H in HLG, that is to say the high-level part, there might be a little too much H here, that it doesn't get sufficiently deep into the weeds. And actually, that's very much the same as what we heard in the very insightful comments from Bruno Lasserre earlier today, where he said that he thought it would be very useful, that it was in some ways a missed opportunity that the HLG didn't go deeper into individual topics, that it didn't actually address actual cases. He was arguing that the way that regulators really get good at working together is by dealing more concretely with specific cases. So again, I really welcome experience, especially from Robert Mourik and from Martijn, because you've actually seen this firsthand.
Shall I take the initiative? Yes, well, the high-level group, the DMA high-level group, is a new animal, and it always takes a little while for that animal to get established and figure things out. But I partially recognize what Bruno Lasserre said about the high-level group. I think what my personal experience is, and what we have discussed with the Commission as well in the last few months, is that the high-level group too much was the Commission telling us what they have done, but then you don't have enough information to actually advise them on, oh, in that kind of a case, have you looked at this, or have you tested that methodology, or have you, so we had enough information to hear how busy they were and what they have been doing, and all very helpful, but we never got down to the brass tacks of actually discussing the case more in more detail. What does work very well is that there are quite a lot of subgroups, some ad hoc, some continuous, where the staff of our regulators, the staff of our agencies, help the Commission on very specific topics, and that has worked very well. So I may not be able to draft a terms of reference for Meta or something like that, but my people have helped the Commission with that, and that has been, as part of that framework, been very helpful and very successful, I think. I would say the jury is still out. We can still intensify and improve that way of working. It now looks a little bit too much like any other comitology committee that meets in the Centre Burchette, and we need to get a bit more involved in specific cases. But there is definitely, I think, a lot of a future there.
That's good to hear. Actually, by the way, I should say, and since I was channeling Bruno Lasserre, he wasn't really critical. I think his words were very much praising the high-level group as an important initiative, and I would actually see the same. Rather, he viewed this more as a missed opportunity not to take it further. So it was really much more positive, perhaps, than I cast it. Martijn, what do you think? You've had at least some exposure.
Yeah, so to put this in perspective, was it in December? It was the first time I joined the high-level group as member of the delegation of the European Competition Network. I think indeed the optimistic side of it is that there's a lot lot of potential. But I wouldn't see this for now as kind of an example of how we should cooperate together. I mean, you have to imagine that so representative bodies of the telecoms regulators, the media regulator, competition regulators, privacy regulators,
Consumer.
and consumer protection are sitting. You know, they choose from each network 5 or 6 representatives. They sit in a room, I think, bigger than this, with a table that is in the middle, and you sit around it. And there is, I mean, really, there is not a lot of discussion possible. And so it's basically statements that, you know, the Commission kind of sends information, then the organizations, of course, they have to liaise with their own members to come and read out prepared statements. I mean, it's important. I understand. It's also the symbolism is important, and the fact that you are in one room together. But in order to get these networks to work together, there's a lot more work that needs to be done. And I think it's really good to get to the nitty-gritty of actual cases and stay away a bit from the not necessarily the high level of the participants, but the high level of the discussion. Second thing, and that is a problem, is that particularly for our agency, but it will be the same for other agencies. You know, we also need to do just day-to-day work and cases. And there are so many European boards in which we need to participate that, you know, you can only spend your hour once. It's a scarce commodity. So that's also something that we need to think and that it is just impossible for all member states, according to the entire archipelago of European enforcement, to be represented in all these areas. That is just simply not doable. And it would be a waste of resources if we try.
So okay, those are good observations. I'm reminded of Clarisse Giraud earlier talking about getting the different networks together in the UK and saying you would need a very big room. So I think what I'm perhaps hearing from both of you so far, well, over to you in just a minute, Anu, is that probably the delegation down to more specialized groups at a more workable size, a more manageable size, is where a lot of the real work can get done. And that probably says a lot about institutional design for how this needs to happen.
Yeah, I agree.
I just see nods.
Yeah,
okay.
yeah.
Okay, good. So I don't think you're directly involved, but you surely have views on this. What do you see as working here and what not working?
Well, yeah, on personal level, I'm not, but the EDBB is a member, and we do have a presentation there. So it was very interesting to hear your thoughts. And when you are talking about the nitty-gritty work, and I think you mentioned the subgroups. To my understanding, there is a lot of work done at that level as well. Well, we do need to cooperate somehow. This is now the framework which we have for this work. We have seen that our role there is to bring the expertise on data protection on these tables. Whether there is a room to improve the cooperation, I think this is something we can always discuss. It's always healthy to discuss how to improve the cooperation. But then it's also important to see what is the best level to tackle the different questions. There are the subgroups, and perhaps some technical issues are best dealt at that level.
Thanks. Good thoughts. Now, before we go to Jan, one more question actually to all four of you, and that has to do with one of the conspicuous omissions in the high-level group. Martijn, you'd mentioned that you decided subsequently to bring in cybersecurity, and that's something that's sort of conspicuously not in the high-level group. Do you think that that's a significant failing, or do you think that it's not a big deal?
I think I can only speak for what it was at the national level. At the national level, I think we couldn't do real cooperation without them. I find it too early. I just simply do not know enough whether that would apply at the European level as well.
Okay, thanks. That's a fair point. But I think these are important issues, and I think they're implicit in a lot of what we heard as well today. Whether you think of a collaboration model, as we're talking about now, or whether you think about taking it to a further level at some kind of super agency, the question of where you draw the line is really hard, and essentially how to have enough collaboration without making it so large as to be unwieldy or unworkable. Poses some really fundamental institutional design challenges. Now with that, over to Jan. You know, in American baseball, we talk about being the fourth, getting to bat cleanup. So why don't you give some impressions on actually everything you've heard up to this point? You were really good on the last round.
Wow, on everything. Okay. I just wanted to make a brief remark, but I can also try to make a bigger one. One of the one things that hasn't been really mentioned yet is that on top of these design questions, and I totally agree that, I mean, in the high-level group, and we were talking Putin-sized table, right? So this is really difficult to kind of work around this, I think. But the one thing that I think is also missing, and that has only been trialed now in the context of the DSA for the first time, and I applaud the Commission for trialing this, is a more structural involvement of civil society organizations. And I'm not saying this because we love to have more work. I think we're like really, really charged with stuff already. But because we're not running around as lobbyists here defending kind of personal interests or something, we're working in the public interest. So we have in this context an interest in those laws being successful. We want these things to succeed. We want the EU to succeed to uphold our laws towards the companies that are being regulated under them. And we can only do this if there is some form of involvement. Now the DSA gives some possibilities for that, but the other laws do not automatically allow for these things. And so the question is, can we build these fora in a way to allow for expert input on a more formalized or more regular basis. It sounds to me that when I listen to these conversations around here, which I find really quite fascinating, is that a lot of this comes also down to trust and the question of, is an agency, is an authority willing to give up power? Can we share the turf? Because obviously, when you collaborate on these things, there is always some degree of decentralization going on, and you know, I guess you have a lot of experience, Anu, with that, and under the GDPR, because the model is a lot more decentralized, and maybe that has had weaknesses for other reasons. But I think generally speaking, if we do agree that there is a massive body of work to be done that cannot be done by any single authority alone, if we do agree that there is an enormous amount of expertise in all those authorities, in all 27 member states, that we just somehow need to bring together, then decentralization, I think, is key. If not of responsibility, then at least of the work to be done. But again, this requires trust. People need to know each other, and they need to have, and I think that might also be crucial in many situations, need to have the political backing to then also just go and do it. And I find it impressive that you said you were able in the Netherlands to kind of lead your decision makers towards it, and they were willing to go with your proposal. That is fantastic, but I'm sure this isn't the regular kind of way it works in many member states. So I think that would be one of the requirements, and I would very much encourage everybody working in this space to seek that political approval. Civil society definitely will try to support you wherever we can.
Good to hear. Now, I know Anu wanted to jump in here. Here you go.
Yes, just to say that indeed we have a lot of experience on the decentralized model, and I would actually say that it works quite well now. We have done over 2,000 final decisions within the one-stop shop mechanism. But it's not only about sharing the work, it's also about being close to the data subjects. That's also an important element of the authority, and what are the elements we need to put together to have a good coherent system.
Okay, thank you very much for that. I've got one last question actually to toss out for whoever cares to jump on it, and then we'll hand off to the audience, and that is, for the various things that we've talked about, collaborative models or more, how much can be done with purely voluntary initiatives or non-governmental? I think we've already seen with Clearinghouse 1 that there are limits to what can be done. How much requires hard law? What, if anything, might require treaty change?
Can it's not directly on, because it's impossible to answer the question, I think. But I think what we shouldn't forget, that the most important part, and that is trust and culture, a culture of cooperation, and that's what you get by working together. So what we as leaders in the Netherlands of our agencies constantly push into our organizations is just start working together, and do it, and not wait until there is a memorandum of understanding, until there is a law or a treaty change or whatever it is, because you need to. There's always something that can be improved in the law or in the bureaucratic structure, but actually it shouldn't stop us from actual working together, because that's how you find a common view, a common culture, and the trust necessary to really cooperate.
Yeah. Can I add that one of the complications that I see from a BEREC side and is what we just talked about, and that is what kind of commission are we talking to? Because in the end, we often think that the Commission is a political body. If I say that to my Commission people there, to the Commission colleagues, they get cross and they say that it's not true. But I have ample of evidence that the Commissioner changed and suddenly we are no longer, we cannot take the same decisions anymore because the political wind has changed. So there is this problem that can potentially be solved by just cooperating and working together and see how it goes. But there is a bit of distrust if the Commission is involved, because are they really independent is the question then.
I think these are both wonderful points, and they're nice bookends to one another. And with that, actually, we've got about 15 minutes to hand off to the audience. I already see one hand. Somebody was way. I see lots of hands. Boy. Okay. So why don't we? I'll take as many as I can, but there's a whole bunch of you, so we'll do what we can. Try to be very concise, and when you start, introduce yourself and tell what organization you're primarily affiliated with. I think it helps people to know who they're talking to. I'll first. The gentleman in the sort of maroon shirt who's had his hand up the longest, and then the young lady in the front next to Brendan.
Thank you very much. My name is Robin de Wouters. I'm the Director General of FEDMA, the Federation of European Data and Marketing. We represent marketing service providers, mostly SMEs. I want to point out that what is missing for horizontal cooperation to happen. It seems ironic that there's no industry representative on the panel. It's something that is definitely missing in terms of finding the gaps. I also would like to add that when we talk about public interest, that also involves a strong European economy. So public interest, yes, consumer rights, but also innovation and protecting businesses. So my question, with that in mind, is I'd like to hear the views of the panelists on the space for self-regulation and co-regulation, because they have not really been addressed, but they are crucial aspects when we talk about codes of conduct under GDPR, for example, which have been underutilized in the last 8 years. Thank you.
Let's take 3 questions and then hand off to the panelists to jump on whichever ones you want. I think that'll be most efficient. So in the front, next to Brendan.
First of all, I'm very happy that this event has been convened. SIPL is a great supporter of regulatory cooperation, so very interesting to hear the different viewpoints. Something that Martijn said that sort of reminded me of my previous career in private practice. You said you are looking for ways to exchange information horizontally amongst agencies, amongst enforcement agencies, and I worked a lot in competition law, in leniency applications, etc. So I'm thinking about the right of the parties in this case, where you have to, as a regulator, you rely on self-incrimination, basically self-reporting and data protection. We may have this in data breaches. And when you start sharing potentially confidential information amongst enforcement agencies, that may have a chilling effect on this, which is something the regulators rely on. So how are you thinking through that in this context?
Let's take one more question. Okay, you got your hand up quickly, so there you go.
Is it working? Yes. Thank you very much. My name is Lisette Mustert. I'm an assistant professor of administrative law at Utrecht University. And my question also concerns procedural rights or good administration, because I think, the focus now is very much on what do you need to cooperate effectively, and that is a legal basis. That are ways to sort of circumvent this whole confidentiality discussion. But what we see now, for instance, with the GDPR procedural regulation adopted last November, is that this discussion of effective cooperation really resulted in a flow chart of steps, so to say, on how cooperation can function more effectively for mostly the complex cross-border cases. But a more principle-based approach, grounded in good administration, so due diligence, but also defense rights, is missing there, I think. And that doesn't only may negatively affect the parties under investigation, but also complainants. And the right to complain in all these digital acts plays a very large role, and also means that they should also have a possibility to participate in the procedure. And there's a wealth of literature on integrated administrations and composite procedures. And, well, these networks and all these different initiatives, they create, well, probably the most complex form of composite procedures within the EU nowadays, meaning that there must be a focus on procedural rights, effective judicial remedies. Where do you go if a joint decision follows from input from so many different authorities? And I really wonder whether those principles are also do also play a role in discussions. Thank you.
So we've got three really interesting questions. Let's reverse the order that we've been taking up to now. I think giving everyone a fair shot. So Jan, why don't you take this first and then over to Anu?
If I may, I'm just going to quickly answer to the first question, maybe.
Whichever questions you want to take.
I mean, fair question to ask, absolutely. I haven't picked the panel, so I was just invited to be here. But if I had to take a guess, I don't know your association, but many of the companies that we're trying to regulate, or at least some of them, when it comes to things like the DSA and the DMA, they have been actively impeding the enforcement of these laws, or outright ignoring that these laws even exist, and have collaborating with a foreign power to undermine Europe's digital law. And I think that alone already shows that it's difficult to have a constructive public conversation with some of these players, and that might have played a role in the selection of the panel. I don't know, but I certainly think that some of the panels that I have been on with these companies have been really, really tricky, and not as constructive as today's.
There's a thought. Anu?
Thank you for the question, whether I see that there is a need for self-regulation when it comes to data protection. I think that GDPR itself is quite exhaustive piece of legislation, but of course there are also the possibility, for example, for the codes of conduct and these type of instruments, and for sure these could be good solutions for finding a better tailored, more detailed system or frames for specific sector, for example. Then, when it comes to procedural rights, the regulation for procedural rules, it sets the frames within which we will now function from now on, and. At the EDBB level, we have heard the parties. If the parties have not been heard earlier in the process, we have heard the parties. And also, for example, if I take a look at the national level, from the national perspective, we do always heard the parties. So I don't really know what is the specific case you are referring to, but we do pay a lot of attention to good administration, both at the EDBB level and then also at the national level.
Martijn?
Maybe a quick comment on the waiver issue. My roots are in the private competition practice as well, so I know the practice where leniency applicants give a waiver to the authorities to share confidential information, and I think that I would say in theory at least, that could also work, of course, in other areas. I'm not sure whether the incentives are the same as in leniency. So yes, if that will be if that could be a way to solve the confidentiality issue, that would definitely help. With respect to the co-regulation issue, I just want to point out one of the interesting elements is that we very early in the process, we reached out to the Netherlands industry and industry players, particular innovators and startups. And we said, you know, if you run into issues where one regulator says A and the other says B and you want to solve it, or you are afraid that they are going to do it, let us know and come to us. We haven't seen anybody. So I repeated this call quite a number of times. So I don't know what it is, but and it's not to blame or not to say, well, okay, now it's your fault. But it's interesting that apparently we, even as national authorities cooperating, are not able to kind of bridge that gap with Netherlands small businesses, startup companies, innovators that want to achieve something, and that where regulation could stand in the way, or at least they need positive guidance from the different regulators, which we are willing to give. And then finally, on the procedural rights, we talked about it at the national level, obviously. We have, fortunately in the Netherlands, a fairly harmonized administrative law system, and ultimately it's the agency that takes the decision, and that triggers the rights for defense and for complainants, and everything that comes there. At a multinational level, it's also something that we, for example, discussed at a high level in the ECN, at the European Competition Network, because there we apply the same substantive law, but have different procedural laws with some safeguards, obviously. And there it's extremely difficult to get to a harmonized, principled-based view, because we have all different administrative systems. And to get that harmonized, I think we need a bigger room than this. Let's put it that way. And it would be great, but I think let's focus on actual cooperation now with the tools and procedures that we have before we go into the next phase.
Robert?
Let me start with the question on self-regulation. My background is industry. I walked the streets here for years myself, trying to get an outcome for the company I worked for. But self-regulation, in my view, has a bit of a patchy track record. It's very few or very little self-regulation has really worked, and even when I worked in industry, we weren't too keen on it, because as soon as I said to my boss it is self-regulation, he basically lost interest and didn't think it would apply to us. So I'm not sure exactly what you're talking about, and it has to be looked at on a case-by-case basis, but I'm not immediately kind of saying, oh yes, let's do that. The question about leniency applications and those sorts of things. We have a cooperation agreement as a telecom regulator in Ireland with the Competition Authority, and we maintain joint lists, for example, of people that come to ask for leniency, so that we can administer that in all confidence together, and it has never really caused any issues. So I think there are workarounds based on our experience.
Okay, I'll actually jump in a little bit here myself before we take the next round of questions. I think we can handle one more round. But actually, I tend to be something of a fan of self-regulation and co-regulation in the right place. With self-regulation, obviously an important question is, will it actually be adhered to? So that's going to be very case-specific, theme-specific. As far as co-regulation, something that I think is inadequately appreciated is if you actually look at the DSA obligations for VLOPs and VLOSs, there's really a strong element of co-regulation in that. It's actually the firms themselves that design the obligations to which they're committing, but then subject to controls and audits and the rest from the Commission. So the law never uses the word, but it really is largely co-regulatory for them. Okay, now we have just a couple of minutes. I think I can take two more questions. I saw one hand up there, I thought, and I see one gentleman who's been waiting for a while. All right, how about the two in that row? Please introduce yourselves.
Good afternoon, Mark Dempsey from Article 19. I think just a statement, and it shouldn't be an elephant in the room, but I think it still appears to be. The reason why the DMA and the DSA is directly enforcing the Commission is because of Ireland's abysmal record when they were given trust to enforce the GDPR. They have levied hundreds of millions of fines against the various platforms. How much of that is being collected? 0.16%. Now, if we want to build trust, enforcement is to happen first on the GDPR, which underpins much of the digital acquis. So it's more a statement than a question.
Okay, well, that won't take time from the panelists, or it might actually. I happen to share some of your concerns. Next, please.
Hello. Hi, I'm Maria Kumin, an independent researcher. Thank you for this panel. It's been really invigorating. My question is actually directed to you, Martijn, but open to the rest. You mentioned that at this stage in the maturity of the regulators group, that the one big hurdle is information sharing, lack of information sharing. What would it take to actually afford or to give blanket permissions for information sharing across regulators? And this is sort of a question for other aspiring regulatory groups.
No, maybe I'm kind of miscommunicated. I don't think at the moment in the Netherlands information sharing is the big issue. So we found ways around it, yes, it would be great to have a blanket law that allows us to share information with everyone, other regulatory authorities that are under confidentiality obligations. So that would be nice to have, but not absolutely necessary for the things that we do now. Ultimately, as most of our cases end up in court, of course, will it stand the test of judicial scrutiny? We'll have to see, along the way. So ideally, a stronger statutory fix would be ideal, but we cannot allow to wait for that, and that's why I said it would be nice, but it will not stop us from cooperating.
Yeah, a classic concern has been that for certain kinds of information, if there were knowledge in advance that the information could be shared with other agencies for enforcement purposes, it might actually work counter to getting the information reported. It would create negative incentives. So it needs some thought.
It also needs transparency then of how we work, and we are in a little bit in the same position that you need information sharing, but you can often do that on the basis of an MOU, and you can work your way into it. And ideally, of course, you get a legal basis for it. But with MOUs, you can already go pretty far.
Okay, well, we are exactly at our scheduled time. I see there are more questions, but I guess we should close it now. Just looking to the organizers. Good. So we're right on time. I'd like to give a huge thanks to our wonderful panel, our wonderful dedicated panel who got here despite wind and weather. And so.